Welcome back to another deep dive. Today we are pulling a specific book off the shelf of American history, blowing off the dust and realizing that the cover completely misleads you about what's inside.
That's a great way to put it.
We're looking at a figure who I guarantee you recognize. You've seen the photos. The heavy black robe, the glasses, the slightly weary expression looking down from the Supreme Court bench.
You're talking about Thurgood Marshall.
I am. And usually when we think of Marshall, we think first African-American Supreme Court justice. We think of him as this stately, established figure of the institution.
Right, as the end point, the statue.
Exactly. But the source material we have today, a really comprehensive historical profile and legal analysis, it suggests that if you only focus on the man in the robe, you're missing the most explosive, dynamic, and frankly, dangerous part of his life.
Dangerous to the status quo, absolutely. It's a common trap. We enshrine these figures in bronze, and we forget that before the statue was cast, they were in the trenches, throwing punches.
So the real story is before the robe.
The argument in the source material is fascinating. It basically suggests that if Thurgood Marshall had retired in 1960, before he ever sat on the Supreme Court, before he was Justice Marshall, he would still be arguably the most important American lawyer of the 20th century.
That is a massive claim. You're saying the preamble was more important than the main event.
In many ways, yeah. Because before he was interpreting the law from the bench, he was weaponizing it from the bar table. He wasn't just a judge. He was like the architect of the civil rights movement's entire legal strategy.
Okay, so that's a big statement. Back it up.
Well, there's one statistic from the notes that I think perfectly frames the scale of his dominance before he became a judge.
I think I know the one you're going to cite. It made me do a double take when I read it.
It should. So as a lawyer, primarily for the NAACP, Thurgood Marshall argued 32 cases before the United States Supreme Court.
32, which is already it's a career right there.
That's a legendary career. Usually, if you argue one case before the Supreme Court and don't get embarrassed, that's the highlight. He argued 32. Do you know how many he won?
You won 29 of them.
29 and 3. I mean, that's a batting average that puts him in the stratosphere. And we're not talking about, minor contract disputes here.
No.
We're talking about cases that fundamentally restructured American society. He didn't just practice law. He reshaped the entire playing field on which the law was played.
So that is our mission for this deep dive. We want to go behind the robe. We want to understand the mechanics of this incredible win streak. How did one man, born in a segregated city, use the very legal system that was designed to oppress him as the tool to dismantle that oppression?
And we're going to trace that arc. It's really a journey from being a social engineer, a phrase we'll definitely unpack later, to becoming the great dissenter. It's a move from the sword to the shield, in a way.
So let's start at the very beginning, the origin story. Because you can't understand the lawyer without understanding the boy in Baltimore. He was born in 1908, right?
July 2nd, 1908. Baltimore, Maryland. And right out of the gate, there's a detail about his name that just tickles me. He wasn't born Thurgood.
I saw this. It was a family name, wasn't it?
It was. His birth name was Thurgood. Thorogoed. It was his grandfather's name.
That's a lot of letters for a kindergartner to have to learn to write.
It is a mouthful. And apparently Thurgood, or Thorogood at the time, had a very practical mind even at age 6. He got tired of the teacher waiting for him to finish writing his name at the top of the page. It was just taking too long.
I can relate to that.
So in the 2nd grade, he made an executive decision. He just cut it down. He told his parents, I'm Thurgood now.
I love that. It shows a certain decisiveness. This system is inefficient. I'm going to streamline it.
Exactly. But if we're looking for where his legal mind actually came from, we have to look at his father, William Canfield Marshall. Now, William wasn't a lawyer. He was a waiter. He worked on railroad dining cars and at a whites-only country club.
So a working-class guy.
A working-class guy. But the source material describes him as a man who was absolutely obsessed with the law.
In what way? Did he read law books for fun?
He lived it. On his days off, William would take young Thurgood down to the local courthouse in Baltimore. They wouldn't go to the park. They'd go to criminal trials. They'd sit in the colored section of the gallery and just watch the proceedings, the arguments, the evidence, the objections.
That is a unique father-son bonding activity. I'll give him that.
It certainly beats fishing for some people.
Right.
But the real training happened afterwards. They'd go home to the dinner table, and that's where the cross-examination began.
The dinner table became the courtroom.
Precisely. William Marshall would challenge everything Thurgood said. If Thurgood made a claim, any claim, his father would demand evidence. Marshall later said that his father never told me to become a lawyer, but he turned me into one.
Wow.
There's a great quote where Marshall says his father made him prove every statement, even if we were discussing the weather.
So you couldn't just say, it's raining. You had to, I submit into evidence the water falling from the sky.
You had to build a case. The pavement is wet. The sky is gray. There is precipitation on the window. It taught him that assertion is nothing without backing. It honed that sharp, argumentative edge that would define his career. He wasn't learning to be loud. He was learning to be precise.
Okay, so he takes this sharp mind to college. He goes to Lincoln University in Pennsylvania.
The oldest HBCU in the country. This was the Oxford of Black America at the time.
And was he the studious, serious future justice we might imagine?
Oh, not even close. The profile describes him as mischievous, energetic, and boisterous. He was the guy playing pinochle in the dorms until all hours. He was the guy pulling pranks.
I read he actually got suspended.
He did. He got suspended for 2 weeks for a hazing incident involving freshmen. So, he was participating in the rough and tumble of college life. He was no saint.
But he was clearly brilliant at the same time.
Oh, absolutely. He was on the debate team, and they were just crushing opponents. And look at the company he was keeping. His classmate at Lincoln was Langston Hughes, the legendary poet.
It's wild to think of them in the same dorm, just two college kids who would go on to define the 20th century in completely different ways.
It really was a crucible of talent. But there's a turning point coming. He graduates with honors in 1930. He decides, okay, the law is my path. He's from Baltimore. His father pays taxes in Maryland. So logically, he applies to the University of Maryland Law School.
And this is the inciting incident of the movie right here.
It is. He applies, and he's rejected. Not because his grades weren't good enough. They were excellent. Not because he wasn't a resident. He was rejected solely and explicitly because he was Black. The University of Maryland did not admit African Americans. Period.
We hear about segregation so much that sometimes I think we can become desensitized to it. But for him, this had to be so personal. This wasn't a history book. This was his life.
It was a direct slap in the face. He later talked about how much that burned. Here was a state institution funded by the taxes his father worked hard to pay as a waiter, and they were telling him, you are not good enough to walk through these doors.
So he couldn't go to Maryland.
Yeah.
Where did he end up going?
He went to Howard University School of Law in Washington, D.C., and honestly, looking back, getting rejected by Maryland might have been the best thing that ever happened to him and, to the country.
Why do you say that? Was Howard a better school at the time?
It wasn't just about prestige. It was about leadership. At Howard, the dean was a man named Charles Hamilton Houston. And if Marshall is the hero of our story, Houston is the mentor. He's the Yoda.
Okay, so tell us about Houston.
Charles Hamilton Houston was a visionary. He wasn't just running a law school to churn out people who could write wills or handle divorces. He viewed the law as a weapon. He taught his students that they were not just lawyers, they were social engineers.
Social engineers. That's a very specific, almost mechanical term. What did he mean by that?
He meant that the law isn't static, it's a machine. And if you understand how the machine works better than the operators, you can re-engineer it. You can use the Constitution, the statutes, the precedents to construct a better, fairer society.
So it's an active process.
Very active. But he warned them. Because they were Black lawyers, the system would be looking for any excuse, any tiny mistake, to dismiss them.
So they had to be perfect.
They had to be better than perfect. Houston was notoriously strict. He drilled them on procedure, on evidence, on the tiniest details. He told them, a lawyer's either a social engineer or he's a parasite on society. There was no middle ground. You were there to change the world.
And Marshall thrived in this kind of environment.
He absorbed it into his DNA. He graduated first in his class in 1933, and he came out of Howard not just with a degree, but with a mission. He returns to Baltimore to start his own practice.
And this is where this story gets really cinematic.
Yeah.
Because he doesn't wait very long to sell that score with the University of Maryland.
No, he does not. He opens his practice, and he's struggling a bit financially because he's taking so many cases for poor people in the community, often for free. But then in 1935, a young man walks into his office named Donald Gaines Murray.
And what does Donald want?
Donald wants to go to law school, specifically the University of Maryland Law School. And just like Marshall 5 years earlier, he has been rejected because of his race.
I can only imagine the look on Thurgood Marshall's face when he heard that.
It must have been electric. Marshall takes the case. He teams up with his mentor, Charles Houston, and they sue the University of Maryland. This is the case Murray v. Pearson.
Now, they didn't argue segregation is wrong, did they? That wasn't the strategy yet.
No, and this is so crucial to understanding Marshall's genius. If they had walked in and said segregation is unconstitutional, they would have lost. The Supreme Court precedent was Plessy v. Ferguson from 1896, which said, separate but equal is the law of the land.
How did they win?
They used the social engineer approach. They used the system's own logic against it. They said, okay, Maryland, you say separate but equal. Fine, we accept your premise for the sake of argument. Where is the equal school for Mr. Murray?
And Maryland didn't have one.
Exactly. There was no black law school in Maryland, not one. So Marshall argued, since you haven't provided a separate school, you must admit him to the white one to fulfill the equal part of your own law.
That's a trap. It's a perfect legal trap.
It is. And the judge, Eugene O'Dunn, agreed. He ordered the university to admit Murray.
Marshall must have felt incredible vindication.
Oh, he did. He didn't hide it either. He famously said later that he filed that suit to get even with the bastards.
I appreciate the honesty. It wasn't just high-minded ideals, it was personal.
It drives home that these weren't abstract battles for him, but this case, this Murray case, it became the blueprint for the entire NAACP strategy moving forward.
And this leads us into what the outline calls the strategic shift. Marshall joins the NAACP national staff in New York. He becomes the special counsel, and they start this long campaign across the country.
Right. They realized that they couldn't attack Plessy v. Ferguson head-on yet. The country wasn't ready, the court wasn't ready, so they decided to engage in what I like to call trench warfare.
Explain that. What does it mean?
They went state by state, case by case, forcing states to live up to the equal part of separate but equal. They knew that true equality is expensive, really expensive.
Right. If you have to build two of everything, two medical schools, two law schools, your budget goes broke pretty fast.
Exactly. Take the case, Missouri ex-rel. Gaines v. Canada in 1938. It's a similar fact pattern. A black student wants to go to law school in Missouri. Missouri says, well, we don't have a black law school, but hey, we'll give you a scholarship to go to a school in Illinois or Iowa.
So they're basically outsourcing their civil rights obligations.
That's a perfect way to put it. And Marshall argued that wasn't good enough. He said the 14th Amendment's Equal Protection Clause applies within the jurisdiction. If Missouri provides a law school for whites, it must provide one for blacks in Missouri. The Supreme Court agreed.
So now Missouri has a choice. Integrate the white school or spend millions building a brand new black law school, maybe for just a handful of students.
Precisely. Marshall was making the cost of segregation prohibitively high. He was tightening the financial vice on the South, one lawsuit at a time.
And he wasn't just doing this in education. The notes call him Mr. Civil Rights.
Yeah.
Because he was just everywhere.
He was the legal defense fund. He was arguing about voting rights, transportation, housing, criminal defense. He was traveling constantly, often deep into the South, risking his life. I mean, he couldn't stay in white hotels. He had to stay in people's homes. There were towns where he had to leave before sundown or risk being lynched.
Let's hit a couple of those other key wins because it really shows his range. Smith v. Allwright in 1944.
A massive, massive victory for democracy. This challenged the white primary in Texas. The Democratic Party in Texas claimed it was a private club, so it could exclude black people from voting in its primary elections.
And since the South was effectively a one-party state at that time, the primary was the election.
It was the only election that mattered. If you can't vote in the primary, you have no voice. So Marshall argued that the primary was part of the state's election machinery, so the Constitution had to apply. The court agreed and struck it down. He effectively re-enfranchised millions of voters with that single argument.
Just incredible. And then there's Shelley v. Kramer in 1948. This one is about housing.
This is one of the most intellectually brilliant arguments he ever made. So you had these things called restrictive covenants. You'd buy a house, and the deed would have a clause that says, you cannot sell this property to a Negro or an Asian or a Jew.
And the defense was always, hey, this is a private contract between two people. The government isn't involved here.
Right. And the 14th Amendment only stops the state from discriminating, not private individuals. It seems like a dead end, legally. But Marshall found the loophole, he argued. Yes, you can sign that racist contract, but the moment you go to a court and ask a judge to enforce it, to kick a black family out of their new home, well, the state has entered the chat.
Because the court is the state.
The court is the state. Judicial enforcement of a private contract is state action, and the state cannot enforce racism. The Supreme Court bought it. It completely revolutionized property law.
It's amazing to see how he finds these threads and just pulls them until the whole tapestry unravels. But I want to pause on his principles for a second, because sometimes people think of him as just an advocate for his side. But there's a moment during World War II that suggests something different.
You're talking about the Japanese internment.
Yeah. Executive Order 9066.
This is a critical moment for Marshall's character, I think. The U.S. government was rounding up Japanese Americans and putting them in camps. It was popular at the time. I mean, even the ACLU board, the supposed guardians of civil liberties, was split. They were afraid of looking unpatriotic during the war.
Marshall wasn't split.
Marshall was clear as a bell. He stood against the majority of the ACLU board. He condemned the internment. He saw it for what it was, a violation of due process based entirely on race. He didn't care that the victims weren't black. He cared that the Constitution was being shredded.
That moral consistency is what brings us to the main event, the crown jewel of his career, Brown v. Board of Education.
This is where the strategy shifts. The attrition phase is over. By the early 1950s, Marshall and the NAACP Legal Defense Fund decide it's time to go for the jugular. No more make it equal. The new argument is separate is inherently unequal.
That is a huge pivot. They're not just attacking the facilities anymore. They're attacking the very psychology of segregation.
They are. And to do that, Marshall did something that, traditional lawyers thought was crazy. He brought in sociology. He brought in data.
The Dahl test.
The famous Dahl test. Marshall worked with psychologists Kenneth and Mamie Clark. They went to segregated schools and showed African-American children 2 dolls, one white, one black. They were identical in every way except for color.
And they asked the kids a series of questions.
Simple questions. Which is the nice doll? Which is the bad doll? Which doll would you like to play with? And then the killer question, which doll looks like you?
The results were devastating.
They were heartbreaking. I mean, just soul-crushing. The majority of black children identified the white doll as the nice one and the black doll as the bad one. And when they had to identify the doll that looked like them, admitting that they were the bad one, some of the children would just break down crying.
And Marshall took this into the Supreme Court.
Yeah.
He made this part of his legal argument.
He put it right into the record. He argued that segregation wasn't just separating bodies, it was destroying minds. It was creating a sense of inferiority that, in the words of the final decision, may affect their hearts and minds in a way unlikely ever to be undone.
So let's set the scene for the argument itself. It's 1953. Marshall is up against a giant of the legal world.
John W. Davis.
Yeah.
He was the ultimate establishment lawyer. I mean, he'd been Solicitor General. He had run for president in 1924. He was polished. He used flowery rhetoric. He cited Latin. He was the past.
Then Marshall.
Marshall was the future. He didn't try to outfancy Davis. He spoke plainly. He was conversational. He forced the justices to look past the legal theories and see the children. There's a core argument he made that I think is the most powerful thing he ever said.
What was that?
He asked the court, essentially, what is the goal of segregation? He said the only valid reason for segregation is to keep the people who were formerly in slavery as near to that stage as possible.
He called it out. No states' rights, no tradition, just straight up racism.
He stripped all the varnish off. And on May 17th, 1954, the court agreed. Unanimous. 9-0. Chief Justice Earl Warren wrote, "Separate educational facilities are inherently unequal."
Marshall's reaction was pretty human from what I read.
Yeah, he said, "I was so happy I was numb."
But, and there's always a but in history, isn't there? The victory wasn't total.
No. The court ruled on the principle, but they delayed the implementation. A year later, in what's called Brown II, the court had to decide how to desegregate. Marshall wanted a hard deadline. He said, do it by September 1956.
And the court said,
They used this infamous phrase, with all deliberate speed.
which sounds nice, but it's basically a permission slip to stall for as long as you want.
Exactly. In the South, deliberate speed meant never. It triggered what they called massive resistance. Marshall spent the next decade fighting cases just to get states to obey the Supreme Court's own order. He had to go back for Cooper v. Aaron in 1958 just to get Little Rock, Arkansas to stop blocking black kids from entering high school.
So he wins the war of principle, but the occupation is messy and long.
It was a grind. But by 1960, Thurgood Marshall is the most famous, most successful lawyer in the country, and the government decides it's time to bring him inside the tent.
This starts his ascent to the bench. JFK appoints him to the Second Circuit Court of Appeals in 1961.
Which was a bold move. The Second Circuit sits in New York. It handles huge commercial cases. It's considered the second most important court in the land. But getting him confirmed, that was a battle.
Southern senators again.
Of course. They were not going to let Mr. Civil Rights become a federal judge without a fight. They delayed his confirmation for over 8 months. They held hearings on ridiculous, marginal issues, just trying to slow walk it. But he eventually got through.
And how did he do as a judge? Because being an advocate and being a judge are really different skill sets.
He was excellent. He wrote 98 majority opinions during his time on the Second Circuit, and here's the kicker. Not a single one of them was reversed by the Supreme Court.
Wow!
That is a badge of honor for a circuit judge. It proved he wasn't just a radical, he was a craftsman. He knew the law inside and out.
But he doesn't stay there. 1965, LBJ comes calling.
Lyndon Johnson.
Yeah.
He persuades Marshall to step down from the lifetime judgeship to become the Solicitor General.
Now, for listeners who might not track the org chart of the DOJ, what exactly is the Solicitor General?
It's often called the 10th Justice.
Yeah.
The Solicitor General is the government's top lawyer. If the United States is a party in a Supreme Court case, the SG or their office argues it.
And Marshall took the job.
He called it the best job I ever had. I mean, think about the symbolism. He spent 30 years fighting the government. Now, he is the government. He's wearing the striped pants and the morning coat. He's up there arguing to defend the Voting Rights Act in South Carolina v. Katzenbach. He won 14 of the 19 cases he argued for the government.
Well, we all know LBJ had a bigger plan in mind.
Oh, absolutely. LBJ wanted to make history. He wanted to appoint the first African-American Supreme Court justice. But there was a problem. There were no vacancies. The court was full.
So how do you solve a problem like a full Supreme Court?
With a little bit of Machiavellian maneuvering. This is a classic LBJ story. In 1967, LBJ appoints Ramsey Clark to be the Attorney General.
Okay, Ramsey Clark. Why does that matter?
Because Ramsey Clark's father was Tom Clark. And Tom Clark was a sitting justice on the Supreme Court.
Oh, I see where this is going. A massive conflict of interest.
Huge. You can't have the son appearing as the chief prosecutor before the father on the bench. So Justice Tom Clark felt obligated to retire to let his son have the job.
LBJ forced a vacancy.
He cleared the seat, and then he nominated Thurgood Marshall. LBJ announced it, saying, "It is the right thing to do, the right time to do it, the right man, and the right place."
But the confirmation hearings, they were not a coronation.
No, they were a hazing. The Southern segregationists, led by Strom Thurmond of South Carolina, decided they were going to try and humiliate him.
I read about the quiz they gave him. It's just unbelievable.
It was absurd. Strom Thurmond started asking him incredibly obscure questions about constitutional history. Things like, who were the members of the Committee on Style at the Constitutional Convention? Or asking about the, intricacies of the 13th Amendment debates in the 1860s.
Your questions that I guarantee you Strom Thurmond couldn't answer without a cheat sheet.
Questions nobody could answer off the cuff. It was a high-level version of the literacy tests they used to stop black people from voting in the South. They were trying to make him look unqualified. But Marshall just sat there. He was calm. He refused to take the bait.
And he won.
Confirmed, 69-11. On October 2nd, 1967, he took the oath.
So now we are in the final act of his career. Justice Marshall. He joins the Warren Court. And at first, this is a pretty friendly environment for him, ideologically speaking.
It's the heyday of liberalism. He aligns instantly with Justice William Brennan. They became best friends and ideological twins. The clerks used to call them Justice Brennan Marshall as one word because they voted together so often.
But the political winds shift.
Right.
Nixon gets elected, then Reagan. The court moves sharply to the right.
And this is where we see that transformation we talked about at the beginning. Marshall goes from being the engineer of the majority to the great dissenter. He is fighting to hold the line against a conservative tide.
I want to dig into his legal philosophy a bit, because it wasn't just be liberal. He had a specific view on how the law should work, especially regarding equal protection. The notes mention a sliding scale.
Yes. This is his big contribution to legal theory, and it's really important. So traditionally, the court uses these rigid tiers to decide discrimination cases.
Can you explain the tiers for us?
Sure. If a law discriminates based on race, it gets strict scrutiny, which means the court looks at it with a microscope, and the law usually dies. But if a law discriminates based on something else, like wealth or age, it gets rational basis, which means the court barely glances at it, and the law usually survives.
And Marshall didn't like these neat little boxes.
He hated them. He thought they were too abstract, too removed from real life. He proposed a sliding scale. He said, don't just look at the category, look at the impact. You should balance the importance of the right being taken away from an individual against the state's interest in its law.
Can you give us an example where this really mattered?
The best example is his dissent in San Antonio Independent School District via Rodriguez in 1973. This case is crucial. It was about school funding. In Texas, like in most of the country, schools were funded by local property taxes.
Which means rich neighborhoods have rich schools and poor neighborhoods have poor schools.
Exactly. The disparity was massive. A group of parents sued, saying this system violated equal protection. But the majority of the Supreme Court said, no, wealth isn't a suspect class like race is. And the Constitution doesn't explicitly say you have a right to an education. So, under our rigid tiers, the system is fine.
And Marshall's dissent.
He was furious. It's one of his most powerful dissents. He argued that you cannot treat education like it's some luxury good. He said that while the Constitution doesn't spell out education, education is necessary to exercise your other rights like free speech and voting. He argued that by denying poor kids a good education, the state was permanently locking them into an underclass. He wanted the court to look at the reality of those kids' lives, not just the legal formalism.
It seems like that's the thread running through his whole career. Look at the reality on the ground.
Always. He brought the real world into the ivory tower, sometimes kicking and screaming.
We also have to talk about the death penalty, because for Marshall, this wasn't just a legal issue, it was a moral absolute.
It was. And you have to remember, Marshall was the only justice on that court who had actually represented men on trial for their lives. He had stood next to innocent black men in the South who were being framed for murder. He knew the system could get it wrong. He knew it was racist.
So he opposed it. In all cases.
In all cases. He believed it was a violation of the Eighth Amendment's ban on cruel and unusual punishment. He famously said, "Death is so lasting."
It's a haunting phrase, isn't it?
It is. After the Supreme Court reinstated the death penalty in 1976, in a case called Gregg v. Georgia Marshall and Brennan, adopted a policy of persistent dissent. Every single time a death penalty appeal came to the court and was denied, they would file a dissent. I dissent. I dissent. They did this over 1,400 times.
1,300 times. That is incredible stamina.
It was a form of witnessing. He called the death penalty vestigial savagery. He refused to let the court kill people without him pointing out the barbarity of it every single time.
He was also a strong defender of privacy and the First Amendment.
Very. He wrote the opinion in Stanley v. Georgia in 1969. Police had raided a guy's house for bookmaking and found pornographic films instead. Marshall threw out the conviction. He wrote, "If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch."
Basically, get the government out of my living room.
Exactly. He also supported the right to burn the American flag in protest in Texas v. Johnson. He argued that the flag is a symbol and its strength comes from the fact that it can withstand criticism.
So we had this image of the fierce legal mind, the great dissenter. But what was he like to work with? What was he like in the hallways?
By all accounts, he was a character, a real storyteller. Justice Sandra Day O'Connor wrote about this. She said that in the private conferences where the justices discuss cases, it can get very dry and academic. But Marshall would interrupt with stories.
Stories about what?
About his days on the road for the NAACP. About facing down lynch mobs in Mississippi. About dealing with corrupt sheriffs in Tennessee. At first, O'Connor thought he was just being a raconteur, just, wasting time. But then she realized he was doing it on purpose.
He was educating them.
He was forcing them to see the people behind the law. Every story had a legal hook. He was reminding these other justices, who mostly came from privileged backgrounds, that the law affects real, vulnerable people in profound ways.
There was a negative rumor that dogged him later in life, though. The source mentions critics calling him lazy or saying he just watched soap operas all day.
Yeah, that was a nasty narrative that developed in the 80s as the court became more conservative. People claimed he was disengaged and let his clerks do all the writing while he watched TV in his chambers.
Is there any truth to it at all?
His clerks say absolutely not. Former clerks like Mark Tushnet, who is a huge legal scholar now, have called that idea wrong and perhaps racist. Look, Marshall was old, he was tired, his health was failing, and yes, he delegated the drafting of opinions to his clerks.
Which every justice does.
Every single one, that's the system. But the clerks confirm. Marshall made the decisions, he told them how to vote and why, he edited their drafts, he was the boss. And speaking of clerks, he had an amazing eye for talent. Current Justice Elena Kagan was a Marshall clerk. Cass Sunstein, the famous scholar, was a Marshall clerk. He was mentoring the next generation, just like Houston mentored him.
But time is the one opponent you can't sue. By 1991, he is 82 years old. His health, is failing.
He really didn't want to retire. He used to say, "I was appointed to a life term and I intend to serve it." He famously said he wanted to die at 110, shot by a jealous husband.
That's a great line.
It is. But his body was giving out. He couldn't hear well. His heart was bad. So in June 1991, he announces his retirement, and the press conference was classic Marshall, just pure, unfiltered
I
Marshall.
love this clip.
A reporter asks him, essentially, "Why are you retiring? What's wrong?" And Marshall just glares and says, "What's wrong with me? I'm old. I'm getting old and coming apart." No sugarcoating, just the blunt truth.
The aftermath of his retirement, though, was a bitter pill for his supporters.
It was a shock to the system. He was replaced by Clarence Thomas. President George H.W. Bush nominated Thomas, who the source describes as a far-right ideologue. So you replaced the architect of the civil rights movement with a man who opposed affirmative action and many of the very tools Marshall had built. It was a complete ideological flip.
Marshall died just 2 years later in January 1993.
He died of heart failure, but the outpouring was massive. He lay in repose in the Great Hall of the Supreme Court. Thousands and thousands of people lined up to pay their respects.
And the eulogy was given by Chief Justice William Rehnquist. Now, Rehnquist and Marshall disagreed on almost everything.
They were polar opposites, legally, but Rehnquist was gracious. He pointed to the inscription above the Supreme Court entrance, "Equal justice under law." And he said, "Surely no one individual did more to make these words a reality than Thurgood Marshall."
That is a profound tribute from an adversary.
It is. It acknowledges that Marshall didn't just interpret the law, he forced the country to actually live up to it.
When you look back at his entire life, from the social engineer to the justice, what's the big takeaway? How should we view his legacy today?
I think the most provocative part of his legacy is his view of the Constitution itself. We hear a lot today about originalism, the idea that we should interpret the Constitution exactly as the Founding Fathers intended in 1787.
Right. The whole "what would Madison do"
Oh.
school of thought.
Marshall didn't care what Madison would do. In 1987, during the bicentennial of the Constitution, Marshall gave a speech that really shocked people. He said he didn't find the wisdom, foresight, and sense of justice of the framers particularly profound.
He said the quiet part out loud.
He said the government they devised was defective from the start. It allowed slavery. It treated women as property. He argued that we the people didn't really mean all the people until folks like him fought a civil war, passed amendments, and argued cases in court to fix it.
So for him, the Constitution isn't some sacred relic to be worshipped. It's a project to be worked on, a fixer-upper.
Exactly. He believed the true miracle of the Constitution wasn't its birth, but its life, how it has been expanded and perfected by generations of struggle. It's a living Constitution in the truest sense of the word.
That is such a powerful reframing of the whole debate. It puts the responsibility on us, not just on the guys in powdered wigs.
It does. It says the work isn't done.
If our listeners want to see that mind at work, where should they go? What's a good starting point?
Go read The Dissent in San Antonio v. Rodriguez. The school funding case, it is accessible, it is passionate, and it is a masterclass in how to use the law to fight for human dignity. It's Marshall at his best.
Thurgood Marshall, the man who proved that you can change the world if you are willing to argue about it. Thank you for walking us through this.
It was a pleasure.
And thank you for listening to The Deep Dive. We'll see you next time.